along with the form of complaint. The following process were also filed: the statement of claim, claimant's list of witnesses, claimant's witness statement on oath, and claimant's list of exhibits. The defendant will leave of court, enter appearance, and file his statement of defense and accompanied processes on the 23rd of May 2024. In response to the leave of court, the claimant filed on the 20th of June 2024 its reply to the statement of defense. The claimant instituted this action seeking the following reliefs against the defendant. 1. A declaration that the claimant is entitled to be paid her benefits and her November 2019 and leave allowance of 2019. 2. An order compelling the defendant to pay the claimant the sum of 768,000 naira, covering the period of 2016 November 2019 pension and October 2019 salary and 2019 leave allowance, respectively. Another directing the defendant to pay 4% on the total sum after judgment is given, and also an order awarding the sum of 150,000 against the defendant to the claimant as cost for the suit. The claimant's case. The claimant was employed on the 1st of August 2012 by an appointment letter as an accountant in the defendant's company. The claimant averred that the defendant refused to pay the claimant her pension, which was deducted from her salaries and was not remitted to the pension administrator, and has also refused to pay the claimant her November 2019 salary and leave allowance, and the claimant contends the act of the defendant constitutes a criminal offense and is entitled to damages. That the total unpaid payments for this claimant is 768,002 naira 95 kobo only, and she tendered a resignation letter as required by the rules guiding employees to pay off all her benefits and salary, even after several demands for the outstanding payments. The defendant's case, on the other hand, is that the relationship between the defendant and the claimant is not limited to the letter of employment, but includes modification of offer letter dated 4th April 2019 and marked pharmaceutical handbook. That the defendant did not refuse to pay the claimant her benefits or a November 2019 salary, but that the claimant, who worked as its accountant, could not balance her accounts as she defrauded the defendant in collusion with one Mr. Victor Nwoji and could not clarify why the missing funds were credited to Victor Nwoji by the claimant, which led to a dismissal before the expiration of a 1-month notice in lieu upon resignation. That the pensions contribution of his staff are remitted to the pension administrator, including the claimant's pension. And Mr. Nwoji, who worked as a sales rep for the defendant, committed fraud against the defendant and was under investigation around August 2019 and observed that the claimant fraudulently declared Mr. Nwoji's indebtedness and left him in credit of 10,000 naira. That Basin Pharmacy, a customer of the defendant, returned some goods which was to be used to reduce the indebtedness of Basin Pharmacy with the defendant, but instead the claimant colluded with Mr. Victor Nwoji and used the sum value of the goods returned to offset the indebtedness of Mr. Nwoji. The defendant asked the claimant to clarify the reason behind her using a customer's returned goods that ought to be used to reduce the customer's indebtedness to the defendant, but was credited to Mr. Victor. The claimant, while promising to balance her records with the defendant, tendered her resignation and did not balance her records, and therefore, by the provisions of the company's handbook, the company has the right to dismiss any staff summarily in case of misconduct. Any employee so dismissed will not be entitled to any financial benefits, and an employee will be subject to dismissal if he or she commits certain acts of misconduct. In the event of summary dismissal, no notice or pay in lieu of notice will be given to the employee. That the claimant's action in manipulating figures to favor Mr. Nwoji is fraudulent and an act of dishonesty. On this ground, the claimant was summarily dismissed before the expiration of a notice in lieu of resignation without benefits, and the defendant prays for the dismissal of this suit with punitive cost. In response, the claimant avers that the defendant put in her 1-month notice of resignation dated the 20th of November 2019. That is that and that it was acknowledged by the HR, and she is surprised that the defendant is alleging dismissal in its statement of defense, that the defendant never remitted the pension deducted from the claimant's salary from the year 2016 to 2019. The claimant stated she never cleared any Mr. Nwoji of any indebtedness. She had no direct dealing with Basin Pharmacy, and any goods returned by any sales representative of the company is first received by the MD, who directs the account department to raise an invoice, and which will be returned back to the MD's office for final approval. The claimant states that the investigation of Mr. Nwoji Hello?
We can hear you, my lord.
Okay. The network knocked me off. Okay. So one Adeleke Blessing testified as DW1 and tendered 14 documents in evidence marked as Exhibit D1 to Exhibit D14. In the body of the judgment, I have the defendant's final written address, the claimant's final written address, And I'll go straight to the decision of the court. Okay. Parties are in agreement that the claimant was employed as an accountant via a letter of appointment with effect from 1st of August 2012, and she worked for the defendant until she put in a resignation by a letter dated 20th of September 2019 to take effect on the 19th of December 2019. It is the crux of the claimant's claims that following her resignation, the defendant did not pay her for November 2019. According to the claimant, the defendant also did not pay her leave allowance and equally failed to remit a pension to the requisite pension fund administrator. The defense hampers on the fact that the claimant was duty bound to balance her account before she can be entitled to get a benefit, so it was withheld. Besides, according to learned defense counsel, the claimant was dismissed without notice for misappropriation and other culpable offences. It is tried that civil cases are decided on the preponderance of evidence or on the balance of probabilities, such that the burden of first proving existence of non-existence of a fact lies on the party against whom judgment of the court will be given if no evidence were produced on either side, regard being had to any presumption that may arise on the pleadings. Section 134 and Section 1331 of the Evidence Act 2023. The burden of proof rests on the party who asserts to adduce credible, cogent, and satisfactory evidence in proof of his claims. Section 131 of the Evidence Act and also Ramadan International and Pharmaceutical Limited versus Israel New Citation all provided. The claimant in this suit seeks declaratory relief, which is not granted as a matter of course, but upon the production of sufficient and satisfactory evidence. So where there is an admission or absence of defense, proof of such a belief will still not be discharged. In Ovivia versus Delta State Company Limited, citation provided, the Supreme Court held it earlier, and I quote, the contract of service is the bedrock upon which an aggrieved employee must found his case. He succeeds or fails upon the terms and conditions thereof. Therefore, in a written or documented contract of service, the court will not look outside the terms stipulated or agreed therein in deciding the rights and the obligation of the party. See Cato versus CBN. The defendant has referred the court to the letter of appointment and staff handbook as containing the requirement for the claimant to balance the account, failing which the defendant reserves the right to withhold her benefits. The court has examined closely the letter of appointment Exhibit C1 and observed it contains no such terms. Exhibit C3 is the modification of the offer of appointment, and it equally contains no such term. Reference was made to the employee handbook in the modification of the offer letter as containing other details of the claimant's employment, meaning that they say the employee staff handbook was incorporated to the terms contained in the contract of employment as set out in the modification of offer letter, and both should be read together. In C7 Up Bottling Company versus Ajayi, Baba versus NCATC, citations are provided. Now, it is pertinent to state that the learned counsel appears to be dancing around issues in the defendant's statement of defense. What was averred was that the defendant activated the clause on misconduct/dismissal contained in the modification of offer letter and the provisions of his handbook in dismissing the claimant for manipulating figures in favor of one Mr. Victor Nwoji. The fallacy, permit me to respectfully use such word, of the defendant's stance at a glance is that it appears to be insisting that the claimant was dismissed after she had notified the defendant of a resignation and the dismissal was without any notice. In law, resignation takes effect from the date the notice was received. It is also trite that an employer cannot refuse to accept an employee's notice of resignation even though improperly done. See Ibrahim versus Abdallah, citation provided. The fact that the contract of employment and the employee handbook makes mention of summary dismissal does not respectfully translate to the right of an employer to summarily dismiss his employee without following the procedures set out in the contract of employment or employee handbook in meeting discipline to such employee. It also does not confer on the employer a right to summarily dismiss the employee without fair hearing, as an employee cannot be dismissed for allegations of misconduct or offenses he or she is unaware of. In the instant case, clause 12 of Exhibit C3 provides, and I quote, the company has the right to dismiss any staff summarily in case of misconduct. Any employee so dismissed will not be entitled to any financial benefits. End of quotation. Surprisingly, clause 22 of Exhibit C4, which is the employee handbook, is to the effect that an employee will be subject to dismissal if he or she commits certain acts of misconduct. In the event of summary dismissal, no notice or pay in lieu of notice will be given to the employee. Management may at its discretion terminate or dismiss the employment of any staff without reference to these procedures. End of quotation. While it is true law, it is the law that parties are bound by the terms of the agreement voluntarily entered by them. See Oforishe versus NGC Limited, citation provided. In industrial relations, where there is conflict in documents affecting the rights of an employee or ambiguity as touching the interpretation of its provisions, the courts are inclined to elect for such interpretation or positions where more favorable to the employee, given the fact that he or she is the weaker party in the contractual relationship. In this case, clause 12 of Exhibit C3 appears more favorable to the employee. This nonetheless, as mentioned much earlier, the evidence before the court points to the fact that the claimant had already put in a resignation which the defendant received. This means that the employment relationship between the claimant and the defendant had been determined by the letter of resignation of 20th of November 2019, notwithstanding the fact that the claimant was still coming to work. The claimant was coming to work because she had to serve the length of a notice in order not to make any payment in the said notice. The fact that Exhibit C4 is worded that dismissal can take place without notice does not extinguish the need or requirement for fair hearing, as an employee cannot be dismissed for an alleged misconduct he or she is unaware of and was not queried on. If there are any truth in the allegations against the claimant on a conduct with respect to remittances that were dishonest, the defendant ought to have been ahead of his game to have issued the necessary queries to the claimant, invited here for investigative disciplinary hearings to ascertain the veracity of such allegations before taking a decision. In law, it is often said that one cannot place something on nothing and expect it to stand. The claimant had determined her employment relationship with the defendant by her resignation, so the purported dismissal by the defendant cannot, without notice, so the purported dismissal by the defendant without notice amounted to nothing as mix of unfair labor practice. The claimant alleged that her salary for November 2019 is 87 naira 460 and the allowance is 48,000 naira 840. The defendant did not deny this claim, but rather stated the reason why it withheld payment. The defendant, with respect to the claim on remittance of the claimant's pension, alleges that the calculation made by the claimant is wrong or false, and it had made remittances for all its staff for certain years. But the defendant did not furnish the court with evidence collaborating such stance, meaning that the claimant's evidence on the alleged non-remittance had not been successfully controverted. For the reason, the court finds in favor of the claimant her reliefs 1 and 2 succeeds. With respect to the claimant relief 3, Order 47, Rule 7 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 provides the court may, at the time of delivering the judgment or making the order, give direction as to the period within which payment is to be made, or that or other act is to be performed, and may order interest at a rate not less than 10% to be paid upon any judgment. Having resolved the claimant's claims in a favor, this court hereby orders the defendant to pay interest at the rate of 10% per annum on the judgment sum until same is fully liquidated as a whole. Cost follows events, and as such, and is awarded at the discretion of the court. The court also assesses cost at the sum of 150,000 in favor of the claimant to be paid by the defendant. Judgment is entered accordingly, signed. So this is the judgment of the court.
And the court pleases. We are most grateful, my Lord, for this deserved judgment.
Okay. Okay, thank you.
Mm.